So this is a meeting of the Plainfield Planning Commission on May 5th, 2025. And we are going to discuss the sidewalk policy and have Liam Murphy, a lawyer from Burlington, come in and discuss stuff about the Goddard property. But we usually start with a motion to approve the minutes of the previous meeting. Can we have that motion?
I'll make the motion.
I'll second.
And any discussion on the minutes? All
No.
those in favor?
Aye.
Aye.
Aye. Okay, minutes are approved. And so the next item is the Plainfield sidewalk policy. And I sent this out to Alicia Weiss, the accessibility committee. I sent a copy to Peter Youngberg just for him to take a look at. Alice Merrill had some feedback. And I think I tried to incorporate some of those comments into the sidewalk policy. Just as a reminder, the sidewalk policy we want to have in order to complete the neighborhood development area application. They wanted to see that the town was willing to build sidewalks in the area that it's applying for a neighborhood, which is pretty much closely defined by the list of sidewalks that we want to complete in item number 5 in the policy.
Mm-hmm.
So
Policy live within the town.
I think it would be a select board policy. Peter asked us, the planning commission, to provide I sort of provided a really basic one, and he said, see if you can do something a little more detailed. That's what this is. It would be a town policy endorsed by the select board. So that's it. If you've had a chance to review it, and I'd take a motion to approve it, to pass it on to the select board for them to modify and approve, or just approve as is. So a motion to approve the sidewalk policy as written?
Yeah, I think it's great. I would make that motion.
Okay, and a second?
Yes.
Okay, all those in favor?
Aye.
Aye.
Okay, I'll email it to the select board. It'll show up at one of their meetings and we'll see what happens. So the next item on the agenda is Karen had spoken with Liam Murphy, who is down in one of the Hollywood squares on Zoom, and about our language enabling things to happen on the Goddard campus. And I'll turn it over to Liam. He's probably knows what he's talking about more than we do. Oh, Liam, I think we can't hear you. It doesn't seem like you're muted, but your microphone isn't coming through.
Different microphone.
There we go. That's getting better.
Okay. No, I apologize. Good evening. My name is Liam Murphy. I'm an attorney in Burlington with a firm, MSK Attorneys. I've been practicing in Vermont since 1983. My focus since the late 80s has been real estate and land use. And over the years, I've been involved in a broad range of different land use issues. Currently, one of the larger projects that I did was the redevelopment of downtown Winooski, and as a special counsel to the city of Winooski, and advise them how to redevelop an entire downtown without getting too caught up in the permit issues that could have plagued that development. I'm also providing some counsel to the current owners of the former Green Mountain College, and have been asked to provide some advice to LedgeWorks in regard to how to approach Really the redevelopment of the campus, and if and I had some good discussions with your zoning administrator about what is now permitted, what is happening with the zoning that was approved, and then I guess is up for a revote in a couple of weeks, and then how that integrates also with the current Act 250 situation. So let me, if I have prepared some materials here, and if I could share a screen.
I think that's something I gotta do.
Yeah, you gotta.
Yeah, I think you can now.
So I'll just go through some basic issues here. Then I'm sure you all know a lot of this, but in general, zoning has been is adopted by the state under Title 24, Chapter 117, and it actually gives permission to the towns to regulate in a certain manner. And in general, a very big picture, uses are divided into those uses that are called permitted as of right, conditionally allowed, or some are not allowed at all. And the courts in a couple of cases has distinguished between what is permitted as of rights and the conditional uses approval by the Planning Commission. And the real issue here is that something that is permitted by right, as far as uses go, means that in general, if the use fits in the definition of what the use is permitted, it is permitted. There is very little leeway in judgment on those, and therefore on appeals. With conditional uses, it's obviously very different. The state standards of conditional use approval are incorporated automatically into your ordinance, whether it's written this way or not. You get the authority from the state, and basically it requires a finding of a number of different factors that the proposed use would not have an undue adverse effect upon a series of criteria. Now, what is an undue adverse effect? That has been hashed out over 30 years. There was a case in Act 250 that established the so-called Queechy test, which then has been adopted by the courts as the test of developing an undue adverse standard, and that is to be undue. You have to find first if there's an adverse effect, and then there are some criteria that you have to find to be undue, and that is that it's inconsistent with policies that of clearly written standards of the town, or that they have failed to make any mitigating changes in the project that would minimize its adverse effect, or that is shocking and offensive to the average person. So those are very judgmental decisions, and the things they're applied to are the issue that always gets appealed is the character of the area, and then traffic and bylaws in the area. But there are a number, as you can see, a number of different criteria that has to be met. And so when approaching these uses, the issue really becomes one of what is permitted as far as a use, which then it can be relied on by an applicant, and what are conditional, which then are potentially open to appeal and to judgment. Because determining what's an undue adverse effect on character of the area or traffic or the bylaws in the town are inherently subjective. While there are some standards for each one of those, they can be easily appealed. So in your current regulations, what is permitted in the current rural residential district, and I know, there's some changing of what is permitted, is a fairly limited number of uses: single family, two family, accessory dwellings, and then everything else is a conditional use. In the new ordinance that this becomes a part of the village district, there has been some expansion of those permitted uses, business and professional offices in particular, and but as far as occupancy of property or residential, it's still one or two family dwellings, and multi-family dwellings have also now been permitted. So under the ordinance, if it's not repealed, certainly businesses and professional offices could be used, and multifamily dwellings can occur on campus as a permitted use. But some of the conditional uses that may be ones that are being explored, the campus has now been purchased, and what is explored is really a more broad range of activities that are occurring in the campus, and they're listed here. There is, I have to say, some confusion in your new ordinance, because multifamily, and that's why I hesitated before, multifamily is listed both as a permitted use and a conditional use, at least.
Liam,
Yep.
it's part of the amendment process. We went with the state standard of that multifamily up to 4 units is permitted, 4 units and larger is conditional, and that'll be in the newest amendment. It didn't make this version, so that gets clarified.
Right. But I just copied these from what was online, so
Yeah.
this is not what it says. So okay. So then the issue will be if there wanted to be used as a community facility, a dormitory, even different educational uses than the college, these larger multifamily dwellings, an event facility. There's other uses that are being considered. Would an event facility include a restaurant, a cafe, those sorts of things? All of those issues are conditional use issues. And, what that really means is that if there's going to be an application for those uses, that obviously you have to have a hearing, then and they're all subject to appeal by anybody who is a neighbor or a group of 10 people in the municipality can get together and appeal all of those uses. And that makes that obviously the most difficult part of any redevelopment of the campus, is that there is the risk. And I was on the Goddard board for a couple of years, the college board, and I recognized it's a community that has a lot of diverse opinions, and there may be those diverse opinions could certainly be brought into any applications, and all if there's somebody who can assert that their property is affected by any of the changes, which, if, for example, if it were under conditional use, they can assert that it's not in keeping with the character of the neighborhood, or that could be affected by traffic or a number of other things. They can get those uses can get appealed. So and then there are some additional requirements. Obviously, you have a site plan approval for all commercial development, and that has a series of reviews that has to go through. That would a review without that are more difficult standards, or more, what I would say, more subjective standard is, is it appropriate in the district and not detrimental to other uses in the district and neighboring properties? As an attorney who's done this for 40 years, I can argue that on every end of the day of what that is, because there actually on conditional use, there's been a history of 40 years of case law about what is conditional, what's undue, adverse, and those sorts of things. But what's appropriate or detrimental, who knows? Those are what a court, the Supreme Court has struck down a number of these standards that are similar to this as being standardless, because there's no standard to meet what is considered appropriate or detrimental. So, so a commercial development has to go through, conditional use, has to go through site plan. And as far as I can tell, it's not, while it's not eligible for a planned unit development approval, because when we're not talking here about any subdivision, it's just really a change of use. And let me just say, I'm not talking at all about changes in the buildings, because most of this is reusing the buildings that are there. Obviously, if there were any new buildings or any changes in the buildings, they would have to meet, the requirements for dimensional requirements and all of those. That's really not of concern, because the issue here is really trying to reuse what is there, but for different uses. So in the Green Mountain College in Poultney, they adopted a new zoning district just for the college called adaptive reuse, to allow for the development of that campus. They did it in a couple of different ways. There were uses that were, as of right, permitted by administrative approvals. There were uses that just were subject to site plan. Their site plan doesn't have some of the more, are more focused on landscaping and those things, and don't have that additional language that you guys have in your site plan. And then there are conditional use approvals for some of the larger developments that might go on. But by creating a new zoning district just for the college, and allowing more permitted uses, and limiting the site plan uses to a fairly limited site plan, it allows for a more easier redevelopment of that campus. So that's sort of the big picture of issues that I think that the town has to think about, is how much would like the campus to are there things there that you all would say, well, those uses we're, are perfectly fine with, and we're going to permit them as permitted uses versus those uses that you might impose the more difficult requirements of site plan or conditional uses. Obviously, for let's say an event facility is currently would be required to go through both site plan and conditional use approval. Is that really any different than many of the things that were happening there? A college is an event facility. I mean, in a very big picture. I mean, the theater that was there and the events that they had. So that's, I think, what I think the boards have to think about in looking at this campus redevelopment, is those things that you feel comfortable allowing as of right versus those things that you might want to have in more conditions on, but recognizing that anything with more conditions, particularly with conditions that are more subjective than objective, leaves it open for various challenges. I then want to just talk about what possibilities there are for going forward. Right now, the new zoning is in a very interesting situation, at least until the revote. If it's revoted and approved, then there's no issue. But if it were to be denied, then any application that was made between, I think, now and the date that it was overturned could be a situation where they have this special situation where after the select board warned the hearing, then for 150 days, any application gets reviewed as if it has passed, and it actually gets reviewed. It gets reviewed as if the ordinance has passed. If obviously it gets rejected or overturned, then you go back to what the prior approval is. I wanted to discuss interim zoning because I think this is what I used in Winooski as a way to allow the redevelopment in the most organized and efficient manner. In effect, the city council of Winooski had me write what was in effect a zoning ordinance, sort of like what the adaptive reuse ordinance for Green Mountain College for the downtown Winooski, that made everything that was in a list of uses a permitted use, so that there would not be any appeal. In that case, the city controlled the land, and they could control it through the ownership, and everything had to go through Act 250. So the feeling was it was going to get reviewed by Act 250, and therefore you don't need to have this double review of the city and then also of Act 250. Interim zoning is a very flexible opportunity for the town if it chooses to use it. if the town is, the first sentence, if it's conducting or has taken action to conduct studies or held a hearing on for the purpose of considering a bylaw, plan, an amendment, extension, or bylaw to a plan, basically, as long as you're in the process of thinking about planning new regulations, the legislative body can adopt interim zoning. The requirements are you just have to notice a public hearing and then they can adopt them. Then they're limited to 2 years from the date that they become effective. And that effectively gives the town or the municipality time to then more perfect a longer, fuller, permanent zoning. As it turned out in Winooski, they ended up just making what I had drafted as an interim zoning as its ultimate permanent zoning, with a few tweaks that were learned along the way. So, one thing I would, encourage the town to consider, whether or not, no matter what the outcome of this vote was, is you could consider passing an interim zoning that would be an adaptive reuse zoning just for the campus. That's then within the control of the select board. And now, interestingly, under that bylaws, the actual decision then gets made actually by the legislative body. Well, that's not true. The legislative body authorizes all of the uses as a conditional use, but that the finding that has to be made is not the traditional conditional use of undue adverse effect. It just has to find that it's consistent with health, safety, and welfare in the municipalities and whatever standards that are listed here: capacity of land, existing land patterns, environmental limitations, and the plan. So it isn't a full free permitted use, but it is a more limited review of conditional use approval. I would add the other thing that in the development that I would like the town to consider, at least, is that currently there is an exemption from Act 250 that is in place for, I believe, until December 31st, 2026. But in order to qualify for that, the entire property in Plainfield would have to be part of Goddard, would have to be part of the downtown, or excuse me, not in your case, the village district, the village developmental district, I think it's called. So that's a quick overview, and I'd be glad to answer any questions that you have about those general principles.
Well, thanks. I've got a couple of comments. One is I like the idea of having a separate district for Goddard at some point. Getting to that point might take a little while. As far as the interim zoning proposal, if this zoning revote fails, well, I'm going to think positively, and I think it's going to pass. And we're also in the process of getting a neighborhood development area designation, and the Goddard property will be included in that designation. If we were to have interim zoning doesn't count for neighborhood development criteria. So we tried going down that path with interim zoning, and they won't accept interim zoning. It has to be permanent zoning, and some of the elements we put in the revision meet the requirements for the neighborhood development application. So the interim zoning won't help that NDA application, which is the way to get the Act 250 waiver.
Yes.
And in fact, the limit for legislative approval of a town below 2,500 has been eliminated, so the select board can go ahead and approve the permanent zoning if they want.
But after the
revote.
you have to go through, the planning commission has to hold a hearing, make a report,
Yeah,
go to the hearing, go through that six
Right.
month step.
we could have done that this time, but we voted on the zoning before, and we're just doing it the old-fashioned way, and we're going to vote on it again. So that's what we did at the town meeting. We could have just gone for the legislative approval. Might have not been the best decision, but that's the way it goes. So yeah, the idea of having basically historical uses be permitted on the campus versus conditional use is something that it'd be worth looking at. For this revision, the easiest way to do it was just to put it in the village and have the same standards and essentially have the community have input to what's going on at Goddard. Because honestly speaking, there's a lot of questions in the community about what's going on at Goddard. What are they going to do? That's been going on for 40 or 50 or since 1936 probably, but still
Yes.
there's what's really going to happen. And I know Mike and Sabina are going to have more outreach and we'll get some more information out, but until that, the community feels a little more comfortable of what really is going to go on in there, I think they'd feel a little more comfortable with having those conditional use standards to operate with. But like you said, in the long term, if they're going to be using it the way they have been using it, that's probably going to be an easier path for the town to administer.
Well, that's obviously a question of definition of, there will be hopefully a wide variety of uses of nonprofit uses, housing uses, organizational uses. I mean, Mike's intent is to try to make this a very community-oriented campus. But, so let's say, let's just pick a cafe. That's something that's, where does something like that fall, right? I mean,
commercial services, would it be under that? I mean, basically that's the same language we've had in the village, and we've had restaurants in the village before. I mean, Positive Pie is in there with the same language we had before. I mean, maybe the town made a mistake for doing that, but we've had pizza parlors and Positive Pie with that same language in the village as a conditional use.
Well, I mean, let me just share again here.
We're amateurs here, so we made it work.
So, now let's just go to the village district here. So, that's sort of, we're trying to figure out stuff like that. That's not the only one, but obviously, where is that? If I have spent my career representing all aspects of land use. I represent a number of towns. I represent some of the larger developers here in the Burlington area, but I also have represented a fair number of opposition groups around the state to projects, and I always try to look at something from all of those all of those hats on. And when I look at some of these sorts of things, the question somebody's going to say, well, what can I appeal here? And I think that's the big concern of going forward is, what is it that can be used on the campus, and what is going to have to go through a potentially lengthy hearing and appeal process.
Okay, well, yeah, so if we listed cafe or restaurant, it would make that a little simpler, at least in terms of what we have.
Well, no, that was just an example
okay.
off the top of my
Okay,
head.
yeah, the whole condition.
I'm just trying to understand really what the scope of uses are, and that one just popped up in me as I read the list. I just
Yeah, okay.
didn't see restaurant, and I'm like, well, most downtowns have restaurants. So
well, we so do we. We got it. I mean,
Sabrina just joined this one.
Yeah. Anyone else have some comments?
Or questions? I mean,
yeah, questions or comments? Let's open the floor. Oh, okay. Well, Sabrina, I see you're here. We're talking about basically having about more permitted use and less conditional use options for the campus. And one of the thoughts I had was that hasn't been, or the more comfortable the town feels with what's going to happen at Goddard campus going forward, the more comfortable they would be with saying, okay, these are going to be permitted uses because they've always been there. Like they've always had the cafeteria there. They've always had the hay barn there. They've always had, a concert going on there. So maybe those uses don't need to go through the town's conditional use process. And that's a part of the outreach that you and Mike need to get going.
Great. I would love to get down to those specifics. Yes, we intend to run the cafe. And yes, we intend to run the hay barn. And yes, we intend to have people in dorms. And I think that I would love to, just go a little bit further about what do these individual other changes mean, and what does, our being a part of the village, how does that expand our usage? And, we're still really at these beginning phases of understand the capabilities, all structures that we have to fix, and the ways that we can and will use the property. And I want to listen for what people need and want, and we've heard a lot. And I do not want to promise anything that we can't potentially do, but I do want to know the full scope of what's possible.
Okay, I think that dialogue, once it gets going, would help lead into this thought process that Liam's describing, where there is a separate district for the Goddard campus, that the uses are somewhat more enabled by the permitted use versus the conditional use. And I think that's something that's certainly worth looking at, that the Planning Commission would discuss. But it's going to take a process. Since we had enough trouble just getting the zoning revision done, we've got some work to do ahead of us. But
thank you.
If the zoning, when the zoning passes, it'll pass one way or another, one how or another, that the campus will be able to do a lot of the things. How easily and quickly that gets done, it's hard to say right now.
Right. I mean, I know everybody wants to know all the answers right now, but Mike is a committed supporter of the project. He's also a smart businessman, and all those things have to get weighed.
Yep, I do. Any comments from the public who are here? Michael, Julie, Charles, Scotty?
Yeah, this is Michael. I appreciate the concerns Liam's raising about creating limitations that could jeopardize success of some projects. But there's a flip side also, and that is the town has needs too, and we may want to incentivize or influence some of the development based on those needs. So we may want, for example, David Scheckman wrote to you and others a suggestion about requiring a certain level of affordable housing. That's just one example of something that the town could incentivize through its zoning. And that may, perhaps it would be counter what Sabrina and Mike want, or perhaps it would fit well into what they do want. But I think that the town ought to consider the best use of the property, recognizing that it's private property and not the town's property. But just the same, are there ways that the zoning can be useful to the town to further some of the purposes we might identify?
Thank you, Michael. And I hear the words affordable housing a lot. I've gotten emails about it. And it is very much a statewide, federal, cultural issue. And I think that it's a really, really good question to ask. And I also know that it's incredibly complicated. And so asking those questions with real clarity, like what is the expectation? What is the wish? And how can a property like Goddard College property and a sustainable next best use of the property, how can those very, very complicated things be spoken about with care and thoughtfulness and questioning and respect? It's a tough one. And I've actually seen it I've just seen it thrown out a lot. And I know that Mike Davidson's heart is 100% into taking property and repurposing it, not wiping it out, not redeveloping for some other use, but repurposing it in a way that's hopefully acknowledging its history. Well, this is what we're planning to do. We want to acknowledge its history. We want to repurpose it in ways that honor its history and its best use, and still answer some of the cultural and
You
societal.
can have some LSD parties.
What's that?
LSD parties.
But it's complex, and I appreciate it. But we do not take lightly the question, and we also understand it's really complex. And there's some sort of thinking. I'm sure I'm not the first one to bring this up, that Mike Davidson's going to come in and answer all the questions. That's not who he is. He's not Mr. Moneybags. He like takes on projects that nobody else will take on. And we need to, figure out the best way that this works for everybody. So we're here, we're listening.
Liam, I have a question. The zoning is kind of a limited toolbox for incentivizing affordable housing, other than like we have a PUD which grants greater density if 50% of the houses are defined as affordable. are there any other tools that like zoning?
Sure, I
can-
mean, yeah, no, Burlington, South Burlington, number of other communities require that any new housing have a certain number of affordable units, perpetually affordable units based upon the sizing. So if you're building, and it ranges, let's say between 10 and 20%, depending on the community and depending on the size of the development, that there are requirements that say, if you're going to build a new structure with housing, then and then usually it's only when the structure is more than 4 units. I mean, traditionally 4 units and under have been considered and are exempt from that in these communities. It doesn't necessarily have to be, but if you're building something new, then often towns will impose a minimum affordable housing part of that. Now, what's complex about that is you then need somebody to administer that program. When I did the first one in South Burlington, they didn't have anybody to do the calculations and to do the checking on the persons who were coming in, who were applying. And in that case, they had to engage, at that point, it was the Champlain Housing Trust. I think they're now called Evernorth or something. They had to have somebody else do that. So it can be done, and it is done. It's just not, you just can't go in and say, all right, every house that's built, or for every 10 houses that are built, you're going to have 2 of them to be perpetually affordable, without also having the infrastructure to do that, because you still have to have somebody who vets the person, make sure that they are meeting all of those standards and stuff like that. But it certainly can be, on affordable housing, there can be incentives there. I have to say, I've represented a lot of housing developers who sometimes will, based upon those incentives, will limit what they do depending on where the notches are. Sometimes if you have a unit more, that then requires you to have another affordable unit, they may strike a unit out because they don't want that notch. But it can be done, and it is done, and there are lots of examples for that sort of thing.
Are there state standards that are newer state standards or newer regional, like the
No.
work with the Regional Planning Commission? Okay.
No, there are, clearly the Department of Community Housing and Development probably has some models that they've done. I haven't looked, but I would guess that they have some models, because I know a few communities have adopted it. So I'm assuming there's some models out there of that. But there is no, the Title 24, Chapter 117, where you get your authority for, does give you permission to impose affordable housing requirements.
There may be something in the neighborhood development area too. I should go check that, if that enables
Yes,
the standards.
right. And
that may
that's
well
community.
help
yeah.
us on that
So
in terms of framework.
could I just add one thing?
But I think, but let me just say, I think one of the, generally these are applied to when you're doing new housing. I mean, one of the challenges here is you have a number of existing buildings that need to be renovated and in order for them to be occupied, and there's a balance there of costs and all of those sorts of things, but that's in every situation.
But before, Michael had something, Sabrina, just before you go.
So
A question.
2 thoughts.
And
I don't know who's speaking.
I think her the internet connection is sort of frozen. So Michael, you can take the
Okay.
floor. You got the internet.
Okay, so um, I had two thoughts. One, the gathered dorms, when if they get developed into apartments, I wouldn't expect they're all going to be uh, expensive or market rate apartments in the first place. I don't even know if it needs to be incentivized because it could be that we're going to end up with a bunch of affordable apartments in those dorms, but maybe not. Who knows? But the other thought I had that I wanted to toss out was that we're talking about what's in the authority of the Planning Commission and zoning regulations, but there's also tax incentives and other things that that the Planning Commission could do in concert with the Select Board to maybe incentivize in other ways. You know, maybe reduction in property tax or other things to incentivize that, and that makes it more attractive to the developer because now they're reducing their costs.
Yeah, let me say I've been analyzing that exact issue for uh, Pulteney, and while the state statute does give authority to enter into tax stabilization agreements, it's not very friendly to the towns. The, the way it's currently written, and I'm not saying it can't be changed and shouldn't be changed, is that if a town enters into tax stabilization with an entity, first you're going to get town approval, of course, and maybe even voter approval. But then if the state then insists that whatever money they would lose from their educational portion of the taxes on that tax stabilized property has to get made up by the community. So it's possible to do, but unfortunately, as written, once towns look at that outcome, it's difficult.
Okay, thank you.
Sabrina, you had some thoughts?
Well, I just had a question, and it's for Liam, and I don't fully understand it, but I wonder, we're looking at a repurposing of this property and finding a sustainable way to make it happen, which is, some commercial, some educational, some arts-based, some nonprofit, just this multi-leveled piece. And is it, and the reality is our mission, at least as the managing partner of the property and the ones who are bringing the business into what was the college campus, is all educational and is all art-based. How does that affect the affordable housing
Yeah,
piece?
well, affecting the affordable housing piece, one of the issues that may have to be decided at some point is whether the campus is divided into different lots that are maybe owned by some nonprofits, because as long as the underlying property is owned by a for-profit, it's fully taxable. So, certainly it would be possible to take a portion of the campus and say, okay, that portion is going to be owned by a nonprofit and run by a nonprofit, and therefore maybe exempt from taxation. But the law is pretty clear that as long as you have the underlying owner is a for-profit entity, that it's not exempt.
My wife's the lister of the town, and it's a small town. Everybody does. And a nonprofit is a federal qualification, but for local tax purposes, it's at the discretion of the listers. So the health center in town is a federally qualified nonprofit. They were tax exempt. I mean, they were subject to local taxes. They had an act by the legislative body, the state, to exempt them from local taxes. But any other nonprofit is federal taxes, not local taxes. Just want
Right.
to keep that.
Well, yeah, yes and no. I mean, it can, you know, the test is a little broader than that. It's just not every 501c3 is tax exempt. There are broader charitable purposes that have to be required. But it is both that they have to own the property and operate the property. That's the key issue in those situations. Yeah, that's the key issue. That they have to own it and operate it as a nonprofit.
Yeah, and our wish is to draw business and residents and workers into this space because they're ultimately interested in the creative process and experiential education, which is what Goddard has always been. And the split of what will be commerce and what will be nonprofit is, yet to be defined. And I know that Mike's heart is in supporting this property being sustainable and beneficial to everyone here. But how that all plays out, is certainly still at the very beginning phases.
So thank you. I'm sorry, but I have a meeting at 8 o'clock, so I have to duck out, but I appreciate everybody's responses.
Thank
Bye-bye.
you, Michael.
Thank you, Michael. We'll see you.
Bye.
Any other public comment? We like it when people show up, and we like it even better when you say something. So,
I have a question.
Yeah.
So, you gave the example about the other college, right? Is that a PUD or is it just one whole how are they operating in terms of the different buildings?
The different buildings are, it's not a PUD. Again, as in the campus, it's not split up. It's currently owned by one owner. So and again, it's focused on the reuse of buildings, which is, different than when somebody's coming to build a new building. So in that case, the entire campus is within the campus. Where'd that go? The entire campus is part of the redevelopment district. Let me just share that map again. So you can see the entire campus is the district.
Do you permit individual buildings then? Or
Okay, so remember, we're talking about, and this is always something to try to remember with zoning. There's the building and dimensional and density
Right.
and side, and then there's the use side. So if a use was, let's say you're changing in this campus, you wanted to put a daycare in an existing building, you would just come in and say, we're putting in a daycare, this building, and it's a permitted use, just the way you would as if it's a single family house or duplex on a, residential lot. They have to, you're not, all of the buildings are pre-existing non-conforming, or some may be conforming, some may not be conforming as far as the buildings are there. So it's just a use issue. Now, one of the things that it's just a use issue. And if it were, let's say you wanted to, they were talking about if you were putting in a hotel in a building, then they would have to go through their conditional use process, which in fact in Pulteney they have done that. They're proposing for one of the existing buildings to become a hotel.
Liam, could you send me the language and the map for the Green Mountain College district? That would be handy to have.
I would love that also.
Yeah, I'll send this entire thing to you and
Okay,
you can share it.
Very
Um,
interesting.
This is the entire section. It's literally 2 pages.
we like short and sweet.
Liam, I'm thinking back to your conversation about the conditional uses and sometimes a situation where vague definitions like character of the surrounding area can kind of create openings for development or change of use to take place. I've always imagined that that sort of subjectivity or vagueness kind of gives the development review board the opportunity to kind of weigh that against other considerations. In other words, they're not necessarily bound by the subjectivity to then prevent something from happening. Is that your experience, or is there a situation where the vague language kind of makes it like imperative that a development review board not approve something?
So the legislature has tried, traditionally it was pretty subjective, and that meant not only the DRBs or in the old days, the Planning Commission or Zoning Board, it had a lot of leeway, and then also an opponent can then go to court and say, hey, this building is 3 stories and the rest surrounding buildings are 2 stories, and you get an appeals. But when they have changed it to limit it somewhat, it now is that it has to be when they look at it, it's the let's see, the character of the area one is as defined by the purposes of the zoning district within which it is located, and the policies for the plan. So now you can't just make a broad argument that it just doesn't fit in the neighborhood. You have to say that, for example, that the town plan says this is the village and the village should be vibrant and have a variety of uses. And I don't know what is the introduction in your current regulations? Well, I guess it doesn't. Yeah, so here, what they would have to look at is, has to be served by town water and sewer, mixed use, containing businesses, civic, religious buildings, many residences, multiple uses are permitted. So now, if you're arguing as to the character of the area, then you are limited to arguing that it doesn't fit within those that description of what the area should be, or how it's described in the town plan. So that has narrowed the subjectivity of that discussion. And this is about 5 years old, maybe, that second sentence of the conditional use criteria for character of the area was added.
Thanks. That's helpful.
That is very helpful.
Will, would you send me this kind
Sure,
of?
I can send it around. Sure.
Yeah, and I'll distribute it to everybody. I've got email addresses for.
Because
And-
this one right here is for the Green. This is for the Green Mountain College.
No, no, what you're reading
It's ours.
here is.
Oh, this is
This is-
Plainfield. Okay.
This is Plainfield.
Sorry, I jumped.
No, I jumped.
I didn't jump with you.
Okay.
Cool. Yeah, this would be great. This was part of, Will, I was just like responding back to like, how can I say what we want if I am not fully informed about what we are? So thank you.
Okay, well, any other questions?
My name is Charles Scott, and I'm a Goddard alumnus from some time ago. And I hope I'm not interrupting, but I do have a question about something that I haven't heard much discussion of, and that is that the Greatwood Farm buildings are designated by the town as historic. So does that historic designation add to, or how does it affect considerations such as neighborhood character? Would it affect the conditional uses and the acceptance of some, but not all conditional uses? And would it even affect how the buildings would be renovated in the interior and the exterior? Because I read that the farm buildings are designated historic, and I haven't heard people talk about how that would affect redevelopment of the property.
Great question.
Give me a second. I'm not fully familiar with your ordinances, so I have to.
But I do see the Greatwood Farm buildings listed as designated historic sites, which seems that gives Development Review Board an added layer of consideration for what is done and how they're used.
And it
So
also,
in general, I would say how that would be done is the conditional use criteria has to also look at whether there's an undue adverse effect upon the programs and policies that are set forth in the town plan. And I assume in the town plan, there are designated historic properties, and therefore that would be, you'd have to show that in that case that it would not have an undue adverse effect on those historic
Karen's our zoning
properties.
administrator, and she can address that. She has her hand up.
So we do have a historic site review for buildings, and even I think it applies to land that that the DRB does, and it's usually in conjunction with any permit. Okay, whether it's conditional use or not, there would be a historic site review. Now, historically, we have not considered the internal, the renovations on inside, but things that we have considered, or we've had very few historic site plan reviews. Windows, roof line. The guy who bought the Bailey house, he went all hog and actually put made it look like it did back in the day. So we haven't had very many, but yes, you couldn't do a lot of changing the outside of the historic buildings unless the additions fit within the historic of the pre-existing.
And I'll add that anybody with historic buildings would be good to look at federally funded grants for renovations. And when you do that, open that Pandora's box, you're very limited in what you can do. So that can be a good thing or a bad thing.
Raise your hand.
So if you can look at the screen, I'm showing the zoning section 311, which shows what the Development Review Board has to consider when looking at historic properties.
Julie or David, who's ever there.
Yeah. Hi, Will. Hi, everybody. The Greatwood buildings, I think all of the original buildings are, and I don't know if this is exactly relevant, but they're on the National Historic Register. So they have that designation. They were, looked at by the National Park Service or whatever, and there's you can find that on the internet. And I don't know if that changes the status compared to the town designation, but that's the case.
Only if you're getting any state or federal funds. But if you get any state or federal funds, then you have to meet historic standards for the buildings. Over and above what the town would require for its review.
Okay, any other questions? Okay, then I'll say a big thanks to Liam. You've been very helpful, giving us a lot of things to think about. I may ask a question every now and then.
Don't hesitate. And quite honestly, if I know how, you're generally all volunteers, and it's a lot of time commitment and a lot of work. I am glad if you get to a point where you are suggesting regulations that I'll be glad to draft a draft, and then you guys can edit, because I have examples that have been used elsewhere that you can do some plug and play and say, all right, we like this, we don't like that, we like that, we don't like that. So I'd be glad to provide some of that material for you if you decide you want some help on that.
That'd be great. That's our general modus operandi, is we crib from other towns and change it to fit.
Absolutely.
We get in trouble that way sometimes, but for the most part, I mean, we don't want to make this stuff up. So it's, at least you're not making too big a mistake that way. That's our philosophy. Okay, and thanks everybody for joining. I'll do a set of minutes, and I'll put this, I'm recording the Zoom, and I'll stick it on the town website. So it's a good resource for people to view who can't make the meeting. Okay.
Thank you, Will.
Thank you.
Thank you,
Thanks,
Lynn. Thank you,
Thanks,
everybody.
everybody.
Thank you, everyone.
Good night.
Good
Good
night.
night.